Hello students, in this model we are going to discuss patent filing strategies, the general procedure. Anything under the sun that is made by man can be patentable. What is patentable? As we discussed before, whoever invents or discovers any new and useful process, machine, manufacture or composition of matter or any new and useful improvement thereof may obtain a patent, therefore subject to certain conditions. Why get a patent? A patent can be used to gain entry to a market. A patent can be used to exclude others from a market. A patent can be used as a marketing tool to promote unique aspects of a product. A patent can be sold. A patent can be licensed like other property. What are the requirements for a patent? The invention must be new or novel, not already known. The invention must not be obvious to a person skilled in the art. The invention must have utility. The invention must be enabled, means it must describe how to make and use the invention. The invention must have best mode of way, the preferred way of practicing the invention known to the inventors as of the filing date. When we can file a patent application? First of all, we need to identify innovation. Second point, we need to check whether our innovation has patentability criteria or not. Prior to any public disclosure of the invention, we can file a patent application. If we want to file globally, we should not talk about our invention before the day we file the applications. We need to file early, but not too early. No need to wait for the final product. We can file our inventive ideas as a provisional patent application. Usually, applications are filed on the basis of prototypes. No need to exhaustively test our invention. Possible patent application filing strategies. There are two kinds of patent application. One is the provisional patent application. Another one is the non-provisional patent application. That is complete specification. A provisional patent specification is an application that is filed before filing a complete patent. The word provisional is used because it is an incomplete patent application and a predecessor of the complete specification which comes afterwards. But why we are filing provisional patent application? Means you have innovative ideas, but you did not test those ideas. You did not generate scientific data or experimental data. You did not develop a product based on those ideas. But in this situation, you want to protect your innovative ideas before development. Then you can file provisional patent application. This provisional patent application protects your innovative ideas without having any experimental data. That is the advantage of provisional patent application. It is a document that may be filed before a complete patent specification in the office pertaining to an outlook patent. It describes the invention sought to be protected broadly, but not completely. So even though filing this provisional patent application is not compulsory, but it is highly encouraged as it extends a lots of benefits to the inventor. You have a 12 months time to develop those innovative ideas. You can generate your scientific data or experimental data within that 12 months time. You can file a complete specification with the complete details of your invention. What are the benefits of provisional patent application filing? Provisional patent application establishes a filing date, earliest priority date. After filing a provisional patent specification, an inventor is entitled to an earlier complete patent specification filing date. It ensures the allotment of priority date and has more benefits such as similar inventions which are filed after the filing date of the provisional specification will not get priority before the applicant's invention. If any dispute occurs regarding ownership of the invention, the patent office will take into consideration the provisional patent's earlier filing date as the date of filing. Second point, the examination process will not start at the provisional application stage. Third, the clock doesn't start running on lifetime of patent. It has simpler filing requirements. The initial cost of A provisional patent specification is comparatively lower than that of a complete patent specification, which saves a lot of money for the inventor with regard to provisional fees. It is inexpensive and lesser resources are required to prepare it, since a patent specification can also be prepared by the inventor himself or herself. And claims are not required. And we have 12 months time to generate experimental data. When you take a new invention, you have no idea on what grounds to seek protection for it. However, there is a processing period of 12 months between the provisional and complete patent specification. So this processing time can be used for researching and analyzing the value of the invention in the market and its commercial viability, advancing its features and making it a more viable product for the market. So these are the advantages of provisional patent application. Who can file patent application? In India, the application can be filed either alone or jointly by any person claiming to be true and first inventors. The application can be filed by the legal representative of any deceased person or assignee. What are the potential barring activities to get a patent for your invention? The first one is, if any other patent or publication exists before date of filing, then it can be considered as a strong prior art. Your own publication more than 1 year before filing can be considered as a prior art. Public use more than 1 year before filing. Sale or offer for sale more than 1 year before filing. Public use in India territory before date of filing. So these are the potential barring activities prevent you to get a patent for your invention. Where we can file our patent application? The table shows regional patent office jurisdiction. The states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the union territories of Pondicherry and Lakshadweep. The inventors from this region, they can file their patent application in Chennai Patent Office. The states of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, and the union territories of Daman and Diu, Dadra and Nagar Haveli. So the inventors from this area, they can file patent application in Mumbai. The states of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, Delhi, and the Union Territory of Chandigarh, they can file their patent application in New Delhi. The rest of India, the inventors from the rest of India, they can file their patent application in Head Office Kolkata. Where to file patent application? The appropriate office of the patent office shall be the head office of the patent office or the branch office, as the case may be, within those territorial limits. Residence of applicant or domicile, or the place of business where it is, the place where the invention actually originated. If the applicant has no business or domicile in India, the address for service in India is given by such applicant. The present flowchart shows the steps involved in patent filing till grant of the patent. We file provisional patent application because we want to protect our innovative ideas. Still, we do not have any scientific data or experimental data based on our ideas, but we want to protect. So that we are filing provisional patent application. We have now 12 months time to generate scientific or experimental data or to test our invention. So once you get experimental data or scientific data, then we need to file a complete patent application within 12 months from the filing date of provisional patent application. If you fail to file, then the provisional patent application will be abandoned. After filing this complete patent application, Patent Office will publish your patent application within 18 months from the date of filing date. But if you want to file your patent application a little bit earlier than the 18 months, then we can file a request to the Patent Office. Then the Patent Office will publish your patent application before 18 months time. That is called early publication. We need to file request for examination within 48 months from the date of filing. Once we file a request for examination, Patent Office will take your patent application for examination. If you do not file a request for examination, the Patent Office will not initiate the examination process. Once you file request for examination, then the patent office will start their examination part. If they accept your invention, then they grant a patent. If they have some objections relates to patentability criteria, then they will issue first examination report. After receiving first examination report, you can file your reply to the patent office. If your invention has been accepted for patentability, then we need to pay renewal fee till expiry of the patent. Students, we have discussed till now where we can file patent application, when we can file, how we can file patent application, what is the general procedures involved in patent filing steps. These are the points we have discussed. I hope you understood these points very well. Thank you.